Okay, what happens if you don't get a quick and speedy trial? If you are not given a quick and speedy trial, you can file a motion to have the charges dismissed, potentially leading to your release. Violating the right to a speedy trial can result in the indictment being dismissed and any conviction being reversed. Any conviction being reversed. You could literally be doing time in prison, and simply because you were denied a quick and speedy trial, your conviction can be reversed. All right, even if the defendant is guilty. This can also give the defendant leverage in plea negotiations, lead to a harsher sentence and a delay that is on the defendant's side, making the outcome dependent on who is responsible for the delay. Legal consequences for the prosecution. Case dismissal. The most significant consequence for a prosecutor is the court will dismiss the charges, forcing the case to end. Release from custody. Defendant who is being held in jail pre-trial can be released if the speedy trial right is violated. Okay, you know anybody sitting in lockup waiting to go to trial? Okay, we're going to go over the time limit, the restrictions, the limitations on the quick and speedy trial. Okay, weak plea negotiations, defense may be in stronger position. Potential consequences for the defendant. Extended pretrial detention. The most obvious negative consequences are remaining in jail for a longer period, which can be detrimental, especially if the defendant is innocent, unable to afford bail. Harsh sentences. In some cases, delays can lead to harsher sentences. A long period of time in custody can be used to pressure a defendant in accepting a plea deal, and that's what they usually do. They don't offer you. Nobody even mentions it. The quick and speedy trial, and they wear you out mentally, emotionally, sometimes physically. People get hurt while they're waiting in lockup to go to trial. Weakness defense. If the defendant is responsible for the delay, it could harm their ability to mount a strong defense. What to do if your right to a speedy trial is violated? Consult an attorney. An attorney can help you understand your rights and determine if your speedy trial right has been violated. File a motion to dismiss. Your attorney can file a motion to dismiss charges based on speedy trial violation. Assert your right. You can assert your right to a speedy trial at any point during the process, and that should be done right away. But see, nobody's telling you. So that's why I'm telling you. It's in the public interest, the right to a speedy trial in a criminal law case. What are the benefits? And okay, let's go. What is considered a quick and speedy trial? Speedy trial is your constitutional right to have a criminal trial occur with reasonable amount of time, protecting against prolonged legal limbo, while federal law set a general guidelines of 70 days for indictment to trial. From the one the paperwork is filed until the time they got 70 days. Okay, that's federal. The exact definition is flexible, determined by four-factor test as established by the Supreme Court's decision in Baker versus Wingle. The test considers the length of the delay, the reason for it, whether the defendant arrested for the right, and the prejudice to the defendant. Constitutional basis: the right is guaranteed by the Sixth Amendment. Purpose: to prevent lengthy pretrial detention, avoid prejudice to the defendant from the passage of time, such as a witness forgetting details, and reduce the stress of the accused person. Federal guidelines. Okay, we said that was 70 days. Talked to quite a few people throughout my years about federal cases that they were going through, and I literally gave them copies. Okay, in journals. Okay, so since I'm in Illinois, okay, in Illinois, the time limit for a trial, speedy trial, is 120 days if the defendant is in custody, or 160 days if they are out on bond. These deadlines begin after the defendant is taken into custody, or for those out on bond after they make a formal written demand for a trial. If the state fails to meet this deadline without a delay caused by the defendant, the charges are subject to dismissal. I mean, anybody ever tell you that? I mean, respectively speaking, your attorney, those involved in criminal cases. People often question what my motives were. It's just to get to the truth, abide by the law. I'm a stickler for the law. I found being a stickler for the law is where I always found the truth, and I always found the guilty as charged. But I'm not a lawyer or a judge, just personally speaking, but my self-imposed ethics, that happened when I was young, but it was when I read the rules and the codes, and since I was reading so many laws, this became a part of me, because that's how things are supposed to work, and then you can proceed. Okay, for defendants in custody, the time limit 120 days from the date being taken into custody. Clock can be paused or reset at defendant if the defendant causes a delay. For defendants out on bond, the time limit 160 days from the date of a written demand for trial. Exception: clock pauses. Defendant requests a continuance. The demand for the trial must be in writing and served on the state. And that's ridiculous. I've demanded in court, and it doesn't matter if you put it on paper, but you shouldn't have to. It's your right. They're withholding it from you. So be sure to state it as soon as you walk in court. Start with a probable cause hearing. That'll tick off a judge, because that's where a quick and speedy trial starts. And if there was no probable cause for arrest, the case gets booted that very same day. And for the state's attorney to even bring a case forward without probable cause is violating the oath, which there are penalties for that. That's deprivation of rights. It's strictly forbidden, bringing any case forward without probable cause. And I've seen it happen, and I've seen the public defender go along with it, and I've tried to help people, and the public defender spent months, 9-10 months, one case over a year, almost a year and a half, where they were trying to convince these people, I don't know what I'm talking about. He's just some jailhouse lawyer. But, I had the written law, and I was showing it to them. I said, are you going to believe me, or are you going to believe your eyes? I'm not asking you to believe me. I'm just asking you to believe your eyes. Something these guys aren't going to tell you. Okay, so there's no reason for anybody to be denied a quick and speedy trial. And saying demand for trial must be in writing and served on the state. If your lawyer does that, then he loses his options on billable items. Just thought you should know that. So if you don't bring it up, nobody else will. Okay? The judge is going to say, oh, you have to put that in writing. It's on the record. I'm right here saying it on the court record. You know, I asked my lawyer. He says, nothing. That leaves your lawyer totally ineffective assistance of counsel, especially if they didn't ask for a probable cause hearing. I've walked in on cases where the public defender was telling these people, here, just sign this and you can go. What? Yeah, you don't have to come. It's over? Yeah, that's it. You know, judge is going to drop the case. Well, you know, you won't have to come back. And I will warn these people, you sign that, you're walking out of here with a felony. I says, they're going to do this to you 3 times and let you go the 3rd time, and next thing you know, somebody's coming to arrest you because you're a 3-time loser, you know. Street 3 strikes law. You don't want to go there. You don't want to let them put you there. I said, that's totally ineffective assistance of counsel. I said, you just disregarded the rule of professional conduct, kicked them to the curb. I mean, you're literally defying the oath you took. No. No, you literally, defying the oath, you decimate, desecrate, and defecate on the U.S. Constitution. You can't take the oath and not live up to that and expect to be called an attorney at law, a lawyer. This isn't due process. That's not effective assistance of counsel. That's ineffective assistance of counsel. And the way you're going, that's defective and destructive assistance of counsel. And they would get pissed off, and they go tell the judge and the state's attorney on me. And sometimes they would just throw the case out. And other times, they would drag it through trial. But it would take nearly a year or more. And that was just to try to convince these people just to take the plea deal. The judge ain't gonna like it. And if you take a jury trial and lose, the judge is gonna give you more time because you didn't trust the judge. So you're gonna want to question the judge on that too. I can't count how many times I heard that public defender say that to one of their patsies. You know, the defendant, the people that are supposed to be defending. So, and you know, the state's attorney and the judge not citing your attorney for ineffective assistance of counsel. I mean, your attorney should be the one first and upmost. You know, we're going to go with a quick and speedy trial first. You know, they don't like to ask for a probable cause hearing. You know, in and out the same day. I mean, you could ask that yourself. Tell Your Honor, you know, give me a court-appointed attorney. You know, let's go over the rules of professional conduct and the code of judicial conduct to make sure everybody plays by the book. That way due process plays out the way it's supposed to. I get a fair trial. I have effective assistance of counsel. The only way I'll actually get a fair trial if I have the legal knowledge, known in the rule of professional conduct as reasonable knowledge, to make an informed decision to give informed consent, and I don't have that. So at least let's go over the rules of professional conduct and the code of judicial conduct, the legal responsibilities of all lawyers and judges in a court of law. I'm sorry, I talk too much, don't I? Is the defendant facing multiple charges from the state, from the same arrest, the state must try them all on all charges in a single prosecution. And I've challenged many times a double jeopardy clause. You can't charge person multiple times for the same crime. That's ridiculous. But they do it, though. They do it. Happened to me, happens to everybody. So you'll want to look up the double jeopardy clause and the limitations on that. Other important considerations: compulsory joiner. If the defendant is facing multiple charges from the same arrest, the state must try them on all. I'm not saying, like if you shoot 100 people, no, you get charged with every person you shoot. No, I'm talking about uh, this guy I helped. He got arrested for asking why he was being stopped and frisked, and next thing you know, he's resisting arrest and face down on the car, and they're yelling, "Quit resisting!" He's yelling, "I'm not resisting!" And they got thrown out in a probable cause hearing. But they were resisting arrest, assaulting a police officer. I forgot what else, but no probable cause for arrest. And tried to get the state's attorney and a judge to cite the cop for filing a false complaint, nothing but legal harassment. For the judge, for the prosecutor to go anywhere beyond that, that would be nothing but legal harassment. For the public defender even allow a case to go beyond a probable cause hearing, that's nothing but legal harassment on his behalf, and legal harassment is forbidden if you read the preamble and the rules of professional conduct. State fails to meet the speedy trial deadline after accounting for all the allowable delays. The defendant must be discharged from custody. Okay. Well, people, I was talking to some young lady, I forgot her name, in chat, and I kept trying to tell them there's time limits on a quick and speedy trial. A lot of people tell me they asked for it. Did you get it? Well, after no, see, it's your right. Did anybody bring that up in the very beginning? Your lawyer first and foremost. That's deprivation of rights by your own lawyer. Did he even mention that? Did he even mention the penalties for deprivation of rights? Of course not, because he's the one depriving you of your rights. Is he? That's ineffective assistance of counsel. That's a lack of communication. One would be diligent if one communicated. And communicating, the time limit for a quick and speedy trial, that would have been really helpful for you, wouldn't it? All right. So remember, even people in prison, somebody on death row, say, hey, well, nobody brought this up to me, and, we 10 years to go to trial. What the hell? But it's not me, it's just the law. I'm a stickler for the law. I met a guy, he was in prison for assaulting a police officer, and he was the one that got beat up, and he was in handcuffs, and he questioned why he was being stopped and frisked, and it's quite common depending on what neighborhood you're in, and for the cops just to pull up and walk up on somebody and get up against the car, get up against the wall, and just start going through pockets. And no, that's illegal, number one. Stop and frisk, called a Terry stop. That's a pat down for weapons, to see if they got weapons or dangerous, whatever. They're not allowed to go through your pockets and make you take off your shoes and your socks, and they do some ridiculous stuff. But look up Terry stop, stop and frisk. No, it's going through your pockets and then going through your car. The only way they can do that is if they ask you if they can. And you don't have to. No, you're going beyond your authority. You're acting under the color of law, which is illegal. You know what the penalties are for acting under the color of law? Defying the oath. I'm quite sure if we look up on our phones right now, police code of conduct, we'll find a whole lot of conduct unbecoming of an officer. People, you have your phone with the internet at your fingertips. Use that wisely. Okay, so can you imagine that? It tells you here if you just look it up. I'm just pointing this out to you and reading out loud. Okay. Sometimes people ask me how you know so much because I ask questions. But this was years ago. And me and Dewey Decimal, we were good friends. And once I found the law library, oh, I was like that little kid in the candy shop for the first time. Not a little kid, like a mob of kids. Stormed the place. I was like a bull in a china shop, but a herd of bulls. I like to read, though. Okay. So remember, you literally get somebody out of prison, out of lockup, Uh, I mean, there's no excuse for anybody not telling you what I just told you. No excuse. It's your right. You have a right to a quick and speedy trial, but in order for you to get it, you got to file with the judge. You do. What happened to your counselor at law? He didn't bring it up. Definitely didn't file no paperwork for it. What happened to the probable cause hearing? Probable cause hearing, also called a preliminary hearing, is a court proceeding in a criminal case to determine if there is enough evidence to believe a crime was committed by the defendant and the trial is necessary. The prosecutor presents brief evidence and the judge finds probable cause. The case proceeds to the next stage, such as an arraignment. If not, the charge may be dismissed. I literally listened to a judge tell a plaintiff, a complaining witness in a case, called her a liar. Wanted to know where she got her information. Told her she was wrong and not to say that again. Don't ever come to court and say that about this person again. You can't do that. You can get cited for perjury. You can go to jail. And he allowed the case to proceed. Whoa, and then they went on a trial. What? She lied about everything she said that happened, and he's just like, well, okay, just change your story. Let's not, let's keep all that corporate puff out of it. You know what corporate puff is, right? That's where somebody lies beyond comparison, beyond their means. Highly exaggerate something just to sell you something. That's corporate puff. And that's actually illegal. Okay, so, that's what you want first of all, a probable cause hearing, preliminary hearing. And you got to really get in there, and but even with the probable cause hearing, seriously, you want to go with the rules of professional conduct and the code of judicial conduct, and have the judge and the lawyer, you review them with all of them. They're going to tell you, no, we already know, no. I want to go over all of this. All of this. Okay, so be prepared. Print out a copy, highlight every issue you want to bring up. Because if you don't, they're not going to do that. People say, if they know that's their job, how come they aren't doing it? Don't ask me, ask them. And the only way you're going to make it happen is if you bring the rules and the codes with you. My dad taught me as a little kid. I learned to read and write before I started school. But anyways, he used to like for us to do family stuff. He bought a board game, bought a Monopoly game, and my brothers and sisters, they cheated like crazy and always making up different rules. I didn't want to play with them anymore. And my dad said, why? I said, they always change the rules. I don't know what the rules are. He says, well, they're on the box. I said, where on the box? This is on the inside. So I went and got the box and looked where he told me and seen the rules. And after that, nobody wanted to play with me anymore. That's what's going to happen to you when you present the rules and the codes and you want to go over this due process thing so you get a fair trial, so you want to make sure you get effective assistance of counsel. And the only way they're going to get informed consent from you is if you have the reasonable knowledge to make an informed decision. And the only way you're going to get that is to make sure everybody plays by the rules and the codes. That's the only way you're going to get informed consent. Otherwise, nothing can proceed in a court of law. And no judge is going to want to go over that with you. Their job description. No lawyer. No, try talking to a lawyer about the rules of professional conduct. You know, I see these people on the internet and, audit this, audit that, audit a lawyer, audit a judge. Question them about the rules and the codes. Question them. Ask any lawyer, but first read the rules. And they're going to tell you that don't mean what you think it means, but make sure you went over the letter of the law first and the penalties for violating the letter of the law. Okay? In the spirit of the law, I use the letter of the law so that we all see, say, and hear the same thing. Okay. So I just wanted to go over that with you. Okay. You usually find any reason to proceed with probable cause, and that usually goes because so-called assistance of counsel is weak in questioning, very weak. But if you have a highly aggressive lawyer, if you're highly aggressive yourself and decided you're the one who wants to depose the arresting officer, and you're the one that's actually going to have to bring up everything that the lawyer won't, because they won't. They will limit what they will say, especially when it's a public defender's office. I can't tell you why, but you can ask them. Ask them. Ask them. Make sure you ask them in court, on the record, in front of the judge. Why aren't they making all these issues relevant? All right, people. Nothing but peace and love. May the Creator always be with you and rain many blessings. Long life and good health.